for those policies being paid?
Yes, Your Honor, it is.
And wouldn't it make sense to use written and collected as referring to two different things?
It could well be.
I mean, isn't that the most logical interpretation?
I think perhaps so, that they're certainly referring to two different things. The problem in this particular instance is we don't know what those things are.
But what we really don't know, according to you, is what net means.
That's correct. We don't know what the term net premium means.
And that's because normally net implies net of all expenses.
Well, it certainly means net of something. But the facts in this case reflect that when the 93 statute was enacted, almost immediately, a number of carriers, and respectfully to Mr. Huebner's recitation of the facts in this case, undisputed facts and record evidence, show that by 1996, the department charged with the enforcement of this statute was well aware that there were at least, their words, not mine, $300 million worth of difference between the reported premium under the insurance code and the reported premium under the Department of Labor's analysis.
And that's
they knew that
that's Mr. Witherspoon.
Both Mr. Witherspoon and Ms. Pillar, both of whom wrote memoranda in 1996 about this issue.
But Judge Lewis, didn't the agency interpret the terms net premiums written and net premiums collected to exclude reinsurance premiums except for the following years following the 1993 legislation?
Yes, sir. That's correct. After that period of time, as Your Honor had pointed out, a rule was enacted by the department, which was repealed in 1995. But the undisputed testimony in this case is that as of at least 1994, the department was aware that a number of carriers, and I frankly agree with Judge Clark's comment on this, whether, Your Honor, it's 20% or it's 200%, doesn't really matter. The fact is that the department knew people were calculating their tax base that way, permitted it, then
isn't the fact that only a small percentage of the carriers in Florida were actually doing this, isn't that evidence that the practice was to actually include the premiums?
Well, Your Honor, again, without taking issue about whether it was a small number or a large number, because frankly what we have to do is say if it were 3 carriers, but those 3 carriers constituted 95% of the workers' compensation premium in the state of Florida, or $300 million, to use the phrase that the Department of Labor itself used, that's certainly a pretty good evidence that there's a substantial quantity of those carriers that are in fact interpreting the law in this way. But none of that matters.
The point I guess, Mr. Volpe, and I don't want to put words in your mouth, I understand where you're going here. What you're saying is percentages don't matter. What matters is that the agency knew this and approved it.
That's correct, Your Honor.
And on what basis do you say they approved it?
Well, two reasons.
The fact that they didn't charge them or what? I mean,
well, that they were aware that the deduction, well, I should say that the calculation of the tax basis excluded ceded reinsurance, and they knew it and they did nothing about it. So I would point to the question about when did this first arise as the agency's position. There was a request for a refund by one of our competitors for the year 1996. That refund was predicated upon that company's analysis of net written premium in the 93 statute. The General Counsel took that under consideration. It was under consideration for more than a year. His letter, where he describes what he's going to do to make the analysis, suggests when he gets finished, we'll publish this as a matter of common interest to all other carriers. What he did was expressly permit this company to take the refund. And from that moment forward, the undisputed testimony in the case, and it's not just 3 or 4 letters, there are certainly 3 or 4 letters in the case that we filed in the record, but it's the undisputed testimony of Mr. Witherspoon and others that at that moment forward, they did permit carriers to deduct ceded reinsurance premium. It's undisputed that they continued to permit that practice. In fact, they continued to permit that practice after we made our request for a refund, and indeed after we filed this litigation in this case. So they permitted the practice, they granted refunds, and they're suggesting now that our clients, RISCORP and FHM, are not entitled to take exactly the same approach to the payment of their taxes that they permitted for these other companies. Again, whether it's 20 or 200, the fact is they did permit it. It was, in fact, the position of the agency, and their undisputed testimony is they didn't even change that viewpoint or change that opinion until a large refund request, ours, was made. And frankly, Your Honor, that's simply outrageous to suggest
because you had interpreted the statute. You
had
interpreted the statute to require you to pay on the. You had defined your company in determining how much tax you owed, you had defined the term to include ceded premiums, correct?
Correct.
That was your reasonable interpretation of the statute based upon your previous experience in writing insurance in Florida.
Well, I'm not sure if anybody really got to the point of making a huge analysis of it one way or the other.
So how much
I
money
can
did you
point to
pay?
two things.
How much is your refund for? I forget.
The original request was about $33 million. The actual final judgment in this case is about $22 million.
So the fact that your company paid $33 million in taxes, there was no, I mean, obviously there was some analysis of what you should do and what you shouldn't do before you write that check, I would assume.
Well, I think that's true, Your Honor, but under the circumstances, I'm not sure what level that rose within the company one way or the other.
So
but just because there was a mistake made certainly doesn't indicate that we're not entitled to go back and seek the refund that the law supported at the time.
And this was in 1996 that you say the agency started to?
Absolutely, yes, sir.
So in 1996, so now the legislature comes back to clarify previous legislative intent in 2000. So it's 4 years later, correct?
At least that long.
They're not reaching back 25 years. They're reaching back 4, correct?
Well, no, Your Honor. I would suggest that they have to go back to the earlier enactment, which is at best 1993.
Again, in reference to the 1993 legislation, how does the 10-year absurdity rule apply to this clarification, as only 7 years passed between the 1993 amendment and the 2000 legislation?
Now, frankly, Your Honor, our view on that is it's equally absurd to suggest that the 2000 legislature knew what was in the mind of the 1993 legislature, just as it is absurd that the 2000 legislature would know what was in the 1990 legislature's mind.
Well, then in that argument, then the legislature could never go back, and you would disagree with Supreme Court opinions that say that they can.
No, I think that they can. They can as long as what they do doesn't effectively cause a substantive change in the law. And here, frankly, Your Honor, you cannot read the 2000 amendment as anything other than the attempt by the Department to go back and have the law changed for purposes of impacting this litigation. In fact, if you look at the body of that legislation, they went on effectively to immunize those carriers who had taken the ceded deduction for time periods prior to the statute's enactment. There can't be any question that they knew it was done, and there can't be any question under the stated law from the Supreme Court and this Court that taxing statutes have to be construed against the government and in favor of the taxpayer.
So you don't think that from 1975 forward, the ceded premiums were not deducted by the majority of entities? The legislature is aware of this. The agency is aware of this. Then there's some confusion in 1996. The department issues some letters that perhaps they shouldn't have issued. The legislature becomes aware of that. They realize that there's litigation filed, because obviously that's what the legislature responds to, is issues of problems in the community, and they attempt to address them. And then they come in and they say, well, because of the agency's foul-up, we're going to try to make it as easy as possible for these people to pay the taxes that they owe. But they don't give them relief from those taxes. They just merely say that we're going to notify you what you owe, and we're going to work with you on paying it back.
Well, respectfully, Your Honor, as the legislature itself concluded, there are two interpretations of that statute. One is that if there's a full
Why do you say
immunization.
the legislature concluded that? Is that from the staff report?
It's from the final legislative analysis. It was
And
done
that
on
final
the,
legislative analysis, that was adopted by the legislature when?
Well, it was in the year 2000.
But the legislature never adopted the analysis.
No, I don't mean that they adopted it. I mean simply that the people who were working for the legislature and evaluating the statutes themselves concluded that there was no basis for concluding that there should be retroactive effect, and further concluded that there were two interpretations that could be made of the statute in question, including a full immunization. That's not my case. I don't have to argue that in this proceeding.
But staffer concluded that somewhere in the legislature.
That's correct.
After the legislature had already signed and died.
That's correct, Your Honor.
Counsel, why wouldn't the fact that the legislature in 2000 authorized the agency to seek the underpayments made prior to 2000 solve this controversy and put you on a level playing field with those insurers who excluded insurance costs prior to 2000?
I didn't hear the first part of your question, Your Honor.
Again, why wouldn't the fact that the legislature in 2000 authorized the agency to seek the underpayments made prior to 2000 solve this controversy and put you on a level playing field with those insurers who excluded reinsurance costs